Welcome to Council Culture, the Business of Law podcast brought to you by Byfield. Hello and welcome to another episode of Council Culture, the Byfield's Business of Law podcast. I am joined today by Byfield's Managing Director, Michael Evans. How are you, Michael?
I'm okay. I'm all right. It's a short week. It feels like a long week. How are you?
I said the exact same thing about 20 minutes ago. It feels like such a long week and we've just had that long weekend.
And I've got really bad hay fever. So
Same.
Apologies if I sneeze or something.
We can cut it out probably. So I think let's just dive right in. We're going to start with an old favourite, or maybe not as favourite, Donald Trump again, and this saga of executive orders and where we're at now. The Independent published yesterday about the latest judge to throw out his executive order for Wilmer Hale. It was Alex Woodward, based in New York, that wrote this article, basically detailing sort of what the judge said, how it would be sort of unfaithful to the founding fathers of America to uphold this executive order. This follows another two judges who threw out, one for Perkins Coie and Jenner and Block. So, what are your thoughts on this current situation?
It's getting a little bit boring. I don't know. Add some Harry Potter part, Donald Trump and the saga of the executive orders. But I think that's three for three now have been struck down by not just Democrat appointed judges, Republican appointed judges, and I think this one, the notable thing is the amount of the 27 exclamation marks, which is quite but all of them seem to have commonality of saying these executive orders are unconstitutional on multiple grounds, really obviously. So I know part of the whole project around Trump's re-election was, if successful, to rapidly centralize as much power as possible in the presidency. The Constitution is still, however, a thing. And you kind of get the feeling that the current administration sees the Constitution as a huge annoyance because it's one of the few, the only things currently stopping them from pretty much doing whatever they want are an element of the bond markets financially, the judiciary, which they're completely at war with in the lower courts at least, and linked to that, the Constitution itself. I'm not certain that the president can get rid of the Constitution, nor do away with the judiciary in its entirety, although they seem to be having a damn good go at intimidating the hell out of certainly the lower courts. I guess it just means that the firms that have been targeted can get back to business and get on with business, hopefully, unless the administration fails to follow.
My thing is, what about the firms that have already made deals with Trump on the other side to agree to the pro bono work, etc., that kind of maybe jumped the gun or maybe said yes a bit fast to Trump? What happens to them? Can they then go back and say we don't actually agree with this because the courts have kind of said this is unconstitutional and
Well, I'm not sure that there was anything contractual as such behind those deals. And they agreed to wording on Trump's social platform for him to say this is what they'd agreed to. But I'm not aware, and I've not read anything that indicates there are complex terms and conditions and contractual obligations. We need anything behind them. So I'm not quite sure what. I think the short answer is no. Is it possible that they will face longer term issues and consequences from those not real deals? I don't know, maybe. I don't know. Look, the big firms continue to do well, including the ones that have done deals. I don't think big private equity is about to stop using Kirkland and Ellis, and so on. But when you think about sort of the longer term ramifications, reputationally, possibly legally, somewhere down the line, it could be the case that the firms that did deals face longer term consequences than those that fought and appear to be winning. Obviously, it depends how far up the courts these go, and appeals, and so on and so forth. But there does seem to be the US at this rate is heading towards a proper constitutional crisis at some point here. And this is just one small part of that, because there is a very, very clear rolling, well-planned attempt to give the president as much power as possible, much more power than previously presidents had. And the Constitution is something holding. There is a huge tension between that program and existing frameworks, and underpinning those frameworks, the Constitution itself. So how it plays out, I don't know. I mean, will a constitutional crisis play out via executive orders targeting law firms? Perhaps not. But there's all the signs seem to be pointing to something pretty irreconcilable between what the White House is attempting to do and existing norms, which have to come to a head at some point through legal means or through the courts. And at some point, the Supreme Court is going to be asked to rule on certain
step in. Yeah, exactly. As you say, this in itself might not be the tipping point for a crisis, but it is another brick. It's another to the foundation of something quite concerning. Moving on from that across the pond to the UK, we have a piece written today by Maria Ward Brennan of City AM about the phrase magic circle. Is it outdated? What does it mean? And are lawyers actually happy at being referred to as part of the magic circle? Maria has reported that one magic circle partner actually referred to it as a sign of lazy journalism. As both former journalists here, have we ever used that phrase in our legal reporting? I think I have.
I think this is one of those evergreen stories, right?
Yeah, exactly.
This story could pretty much have been written at any time in the last couple of decades. There were stories about, does a magic circle mean anything? Does it really exist? What is it? Who else should be in it? Should it even be a thing? When I started my career in the early 2000s as a journalist, it was much more accepted. And I remember how pleased the first law firm I worked at, Herbert Smith, were when Legal Business magazine famously announced on their cover that they were joining the Magic Circle and they were now part of the Magic Circle. Unfortunately, none of the other publications really followed on, and it never really became a thing. So despite Legal Business's cover story, Herbert Smith did not really join the circle. But I still have very vivid memories of that. So it's a really peculiarly English thing, this attachment to labels like this, and almost to an obsessive degree. It matters if people think it matters. It matters if people care. And I think enough people still do care for it to matter. And
it's exclusive, isn't it? You're in the club, we're part of the club, you're not. It's that exclusivity that's attractive.
Yeah. Has it faded? Yes. Are the biggest UK firms quite the global force that they were. Not really. Have the very largest US firms sort of run away in terms of market share and overtaken everybody in the last 5 or 6 years? Yes, and there's no getting away from the fact that what was and still is a giant firm, one of the Baker McKenzie too. We were the biggest law firm in the world, and then it took ages to get through that 3 billion barrier, and then while that was happening, suddenly just Kirkland and Latham's just raced past at breakneck speed, and now you're talking about being like 3 times bigger than really big, 9 billion plus. I know relative to other professional services and banks, etc., these are not huge numbers, but in the legal sector, they are massive numbers. And I still find it extraordinary that how quickly, relatively speaking, that happened, where you went from the UK headquartered Magic Circle firms and some of the global firms like Baker McKenzie, DLA Piper, suddenly just boom, Kirkland, Latham, Vaughan that just shot past in the space of 3 or 4 years and have continued to grow since then. And once you have a degree of critical mass, it's very hard to change or shift that. And I still don't think that we've fully have unpicked how and why that happened.
Yeah, I think the landscape has shifted that much that you can't actually group together the UK firms and the US firms. The US firms have come to London and they've really dominated the market. I think that the Magic Circle is completely different, as you say, and I don't think you could even sort of split it into UK and US. It's interesting. I wonder if there was to be a new sort of club. I wonder who would be in it. What would it be called?
Well, Paul Wilkinson did try and do something on this way, where he tried to apply criteria and looking across geographies, looking across revenues, looking across profitability. And with the metrics that he applied, only Latham and Watkins is genuinely global elite across all fronts because they are very international. They have the scale in terms of revenue, and they have that real top tier profitability. Even Kirkland & Ellis, which ticks the others, isn't quite as present in all the commercial centres around the world. So wouldn't quite tick that global reach box. So isn't quite global enough to be global elite under the criteria. So it's kind of, as an exercise, it's kind of interesting. It was about a year ago, I think, that Paul did it, maybe a bit more. But it was slightly academic because technically there was only one firm that fit that criteria. You can't really have a child with one.
Well, exactly. And moving on to sort of another club, which is the law firms that have advised the biggest private equity clients in the UK and Europe. So this was reported on by Habiba Cullen Jafar at law.com. Law.com International analysed prequent and refinitive data about which firms had advised on the biggest private equity deals. We have a number of firms mentioned here, from Kirkland, as you say, Latham, A&O Sherman, Clifford Chance, quite an array here, which is really good to see that a lot of law firms are featured here, and it's not just the usual heavy hitters that we always see and who we think of when we think of private equity deals.
Well, I don't really think of there are no minnows here.
No, there's no shockers.
No, they're all big firms, but I think it's interesting to try and go beyond just the standard deal tables and to take a slightly more sophisticated approach. So kudos to Habiba for having a go here, and because people are obsessed with this. People, decisions. It is the handful of partners who can consistently win these mandates and have these relationships with these biggest private equity firms that are the most in-demand partners, because they are able to secure a steady stream of multi-billion transactions, and the big transactions are what feed law firms and offices. Yes, big litigation does, of course it does as well, but a steady flow, if you can have a big private equity is going to do tens, may do tens, dozens, whatever, of acquisitions of deals every year around the world. If you've got a claim on a significant portion of those, then you have a claim on more fees than pretty much any other lawyers in the market. Yeah. So because I don't quite know what the going rate is these days in terms of fees for, in the mid-market or a sizable but not huge private equity transaction. You'll be talking about several $1 million in legal fees. And it won't just be the corporate lawyers, it will be the employment lawyers, it will be the IP lawyers, depending on the sector, it may be the energy lawyer, it may be lots of different mouths will be fed by that. And so it's a sort of a focal point. They're the sort of like, that's where, the funnel, that it goes through these relatively small number of people who've got the relationships. And it's really interesting that they haven't been as, the magic circle. It was all historically about institutionalizing relationships. And although relationships are somewhat institutionalized here, but they're also very much linked to individuals. And those individuals are mobile, but those individuals are moving between the same group of firms. Yeah. So it's sort of weird. It's more like the private equity is institutionalized with a dozen or so top premier law firms, but the partners kind of come and go between those firms. Nobody blinks if a Kirkland Ellis partner goes to Simpson Thatcher, or a Leighton Watkins partner goes to White Case. But if there are firms outside of that group, people would sort of go, "Oh, what's going on there?" And so that's sort of semi-institutionalized as a club, but then the partners moving around in that club is kind of interesting. So I suspect this feature will get quite a lot of interest. Probably, maybe we may get some feedback on her methodology from the firms that maybe aren't featured in here, or would like to be, or think that actually it's not quite the right way of looking at things, but it will provoke conversation and debate, because this is an area which is of such vital importance to that top tier of firms.
Yeah, I completely agree. And to take it quite sort of meta here in terms of private equity then acquiring law firms themselves, we've got a piece here written by Paul Hodkinson from law.com on, private equity could shake up big law if they were to buy into.
They were to create their own firm.
Yeah, so, exactly.
Yeah. So yeah, it's an interesting one. I mean, it's quite it's not entirely clear whether Paul is, making a theoretical case, or if there is something actually happening here, because towards the end of the piece, he does sort of imply that there may be some conversations going on in this regard. But really, it's about that attracting some star partners to create a new firm, and rather than acquiring a firm. And I think it's really interesting. I've got no idea if it would happen. I don't know if private equity clients would instruct a firm backed by one of their rivals, but private equity houses seem, the clients, the big ones, seem perfectly happy to work with firms that their rivals work with. And again, it's part of that almost, not club, well, I guess it is to extent a club, an elite club of, the top deal makers, knowing that there are only a few top lawyers who really understand their business and can make deals happen quickly, commercially, in the way that they need it done. And There may be some nuances, but I'm pretty sure that KKR is not doing deals in an entirely different way to a Blackstone or another big private equity house. So if you've got relationships, if you've got the experience, if a firm has got the documentation, if a firm has got the expertise, and if a firm has got the skilled associates teams to actually make things happen, giving the clients the service they need, the time frames they need, negotiating commercially aggressively on terms, etc., to ensure that they're favourable, then the legal fees would drop in the ocean compared to the relative value of those deals, even though it's big numbers, most of us. And so, they seem quite happy to work with the same people, but it might be different if that entity was actually owned by one of their rivals. Who knows? I don't know. It will be interesting to see if it actually happens. At the moment, it's just an article, but it wasn't something I think I'd thought of before. And it certainly it's certainly a lot more likely than any of the top firms being bought out by private equity. That isn't going to happen, but you could see this happen, but you are not going to see a top 5, top 10 law firm by revenues get bought out globally, get bought out by private equity. It's just not in the partner's interest.
No, exactly. I completely agree. And I think that as much as this might be quite abstract, we have seen reports from, for example, Susie Ring from the FT, who reported last week on 2 former partners of Allen and Overy, or now A&O Sherman, have launched their own consultancy to advise private equity on buying law firms. So is this more realistic than we think? Because that is quite niche, to launch your own consultancy for this specific sector. Private equity is looking to capitalize on this because of how profitable it is. But as you say, how likely is that to happen?
Well, I think it's they're both former leaders of Allen and Overy. They've both been around top tier law firms for their entire careers. I think in terms of bridging a gap between what private equity wants and what a law firm wants and what is needed to make something succeed, there is definitely a space to do it better than it has been done before. Private equity listed law firms didn't really work. There are 1 or 2 that have made it kind of work, but they haven't proved to be. They've got to a point of stability, but they haven't proved to be great investments for shareholders, certainly retail investors, etc. Private equity has partly, there are examples of it partly working a bit, but again, the incentives fall out of alignment quite quickly. You might have a group of partners who are getting a big payout because they're selling to private equity. But then what about how do you incentivize the next up and coming people? All you have in a law firm traditionally are people and clients.
Well, I'm going to jump in here actually, because I think that the way we're heading, you have people and you have clients, but I think the hook that Susie uses here is the development of technology and the fact that there's not enough investment in that department, and that private equity can maybe come in and really make a difference for law firms there. So could that be another sort of reason that we maybe haven't thought of?
I mean, I certainly think that the level of, AI is going to change your business model.
We've got robots now, people, clients, and robots.
People, clients, and robots to an extent, but outside capital to build scale, to invest in technology, great, if that's really what's happening. If that is really what's happening, because partnerships are strange beasts, and partnerships have their own cultures, and it goes back to that our ambitions and incentives aligned in the partnership with the investor and with that next generation of talent? Does it strategically make sense? If you have got older generations selling out, it's not going to work. Because the reality is that model, there will be less available for the new equity partners. If you're an equity partner and you make good money every year for 20 years, and then this opportunity comes along, and you're going to get effectively 6 or 7 years worth of money in one go, yay, woo, happy days. A person who becomes an equity partner after you is no longer going to be a true equity partner, or depending on how it's been structured, at least will have other mouths to feed. Their work for profits will a smaller share of profits will go to them, because there will be leverage, there will be bank debt, there will be the private equity investors who want their share of the returns. So absolutely, I'm sure there are examples where it can work, but if it's on that model, it won't work, because why would you become a partner there when you can become somewhere else?
Exactly. Yeah.
And not have those mouths to feed, and not feel like an employee or whatever, and not feel like you're working for, you know, the masters over in New York, etc. But yeah, you'll be working just as hard, but not taking as much home. That doesn't really work anymore. However, if it is to scale, if it is to build something, to build a much bigger firm where everybody can, where there's a much bigger pie, in which case the equity partners may well be willing to give up a portion in return for the pie itself growing a lot, because they're able to scale, they're able to deploy technology and invest in technology in a way which makes them much more profitable, then that may compensate. To date, I'm not seeing that work at all.
No.
Private equity investments at all. But can it work? Yes, probably. Are these guys probably the right people to give it a go? I would think so. Is it going to be really hard to do it properly? Also, yes.
Yeah, I completely agree with you. I think that it is quite abstract, and I don't know how it would work in practice. But as we see, you know, there you go. These two, former Allen and Overy, they're giving it a shot in some way, shape, or form. Finally, to kind of round this off here, we've got a really interesting story by Legal Features, written by Neil Rose. It's about a restraining order of a businessman over the continued pursuit of law firms. So the High Court issued a restraining order against a businessman who has refused to accept that his failed 55 million claim against 2 law firms is at an end. So it's basically about, to sort of wrap it up really nicely and put it in layman's terms, a Swedish businessman owned sort of a television or a film company, and he had a TV game called Minute Winner. Another TV game came up called Minute to Win It, and he is basically arguing that that was his idea and they've stolen it. He went to the he went to the court with it. He was represented by Fox Williams. The other side was represented by Wigan. He went to the court with it. It got thrown out. The judge said no, and now he is sort of making claims against the law firms and saying you didn't do a good enough job. And he keeps going back from every sort of angle that he can, to the point where he has now got a restraining order against him to make any more claims, because it's not rational, according to the judge. What are your thoughts on this?
I think it's a bit unusual.
Very unusual. A restraining order against a law firm.
Well, no, it's not against a law firm.
Sorry.
It's against the client.
Against the client, yeah, exactly. Exactly.
But I think, I mean, litigation, once you run out of road, and there's sometimes other avenues, but he's clearly, you know, a road turned into a path, into a track, turned into a little path, and there's nothing there.
Yeah, there's dust. Yeah.
Right. I if I it must be an odd experience for the firms, because obviously, if you're a law firm, clients being unhappy and former clients suing you is, once you get above a certain size, part of almost like the cost of doing business. It does happen. Certainly there are threats and occasion, and from time to time, fairly frequently, there will be action against law firms. Not every day, but most days, there is a new claim filed in my court somewhere in the commercial court system in the UK against a law firm, often by unhappy former clients. The number of those that succeed, very small. But there are lots of those cases at any given time, and it must be, so it's kind of uncomfortable, but also part of the cost of doing business. I guess the question is, it must be very bizarre though when it's being taken to this nth degree.
Exactly. And it kind of, for me, I'm going to play sort of devil's advocate here and say, surely as a civilian, you should be able to access the justice system as many times as you want.
Well, you can't just keep launching the same claim. Yeah.
Well,
the point is, if it gets thrown out and then you appeal and it keeps getting thrown out, fundamentally you're just going to run out of road.
Well, exactly. But why the restraining order against him to issue the restraining order? I think it's another level, isn't it? Because to me, it's like, but if he thinks that he has a claim there, surely he should be able to keep doing it. Well, and I don't know.
It's like,
well, yeah.
If a case goes through the courts, it's appealed, and it goes all over to the Supreme Court and everything, and then after that, unless you do something at a high, like an international court or something where you can tackle it from a different angle, you've run out of road. Certainly domestically, you have been to buyer's corner. So, but you may before that not even get anywhere near there if it's just being thrown out. And so you can't just keep bringing the same.
Saying I'm right.
that would be an extraordinary waste of precious judicial time.
Well, exactly. And he also did try to do the same thing in Sweden, and the same thing happened. Not the restraining order, but his claim being thrown out. So he obviously doesn't have the best argument in the world, unfortunately, and this is what it has resulted in.
Well, certainly in terms of it's being thrown out. I think just we're here talking about law firms, and I think it must just be a very strange experience for firms going to this degree, which goes somewhat beyond the usual threats from an unhappy former client or occasional lawsuits, which any large law firm will face from time to time. And this is that just kind of amplified.
Mm-hmm. Yeah, I agree. It's definitely an unusual story, and who knows? Maybe this will happen again somewhere. I don't know. I don't know how common this will become.
I don't think that there are any trends to be. I think this gets filed under a peculiar one-off.
Yeah. Okay.
Unusual situation. I think if you were to try to draw any trends or particular learnings from it, I think put it under curio, oddity, whatever.
Yeah.
And that's why we're talking about it, because it's nice to look at something which is a bit odd and go,
yeah, interesting.
But I don't think we can say, and the lesson for all law firms here is.
I completely agree. Well, it made for a good story, put it that way. Well, Michael, thank you for joining me today. Covered a lot of ground, and it's been a pleasure as always.
You've been listening to Counsel Culture, the Business of Law podcast brought to you by Byfield. Thanks for listening. Don't forget to subscribe and join us again next week, where we'll be discussing some more of the biggest stories in the legal sector.